Hello students. Be ready for the dictation. Start. 8. Aggrieved by the same, plaintiff, Totaram, preferred an appeal under section 96 of the Code of Civil Procedure 1908 before the district judge, Hamirpur, which was registered as Civil Appeal number 110 of 2004. The appellate court framed point for determination as to whether the judgment and decree under appeal is legally sustainable and to what relief, if any, the appellant would be entitled to. The district judge did not agree with the findings and the conclusions of the trial court and accordingly decreed the suit against defendants 1, 2, 4 and 5. It held that the will dated 12th December 1988 was a valid and genuine document and plaintiff was entitled to a declaration on the basis of the same that he was in possession of the land in question and accordingly injuncted the defendants 1, 2, 4 and 5 from interfering in his possession. It further found that the will dated 16th May 1994 was surrounded with suspicious circumstances and as such could not be relied upon. Aggrieved by the judgment of the First Appellate Court, the defendants preferred second appeal under Section 100 of CPC, which was registered as RSA number 392 of 2005 before the High Court of Himachal Pradesh. The High Court confirmed the finding of the First Appellate Court that the will dated 12th December 1988 was a valid and genuine document. It also found that the second will dated 16th May 1994 in favor of defendant number 1 Vikram Singh was not a genuine document and was shrouded with suspicion. However, the High Court felt that the purchasers from defendant number 1 were entitled to benefit of Section 41 of the Transfer of Property Act 18821 and accordingly saved the transactions in their favor. They were entitled to retain the land covered under their respective sale deeds and the remaining land covered under the will would stand declared in the ownership of the plaintiff, Totaram, and that the defendant number 1 Vikram Singh would not be entitled to claim any such benefit over the remaining land. The High Court also set aside the mutation entry number 201 but saved it with respect to the transfers made in favor of defendants 2, 4 and 5. It further restored the mutation entry number 207 in favor of defendant numbers 2, 4 and 5. Para change. 9. Aggrieved by the same, the legal heirs of Totaram, that is, his 3 sons, 3 daughters and widow, have filed Civil Appeal number 8187 of 2023 to challenge the judgment of the High Court to the extent it saved the transactions in favor of defendants 2, 4 and 5. The other Civil Appeal No. 8188 of 2023 has been filed by Vikram Singh, defendant number 1 with respect to the declaration of his will dated 16th May 1994 to be an invalid document shrouded with suspicion. On behalf of the plaintiff's appellants, the submission is that the High Court fell in serious error in extending the benefit of Section 41 of the TP Act to the defendants 2, 4 and 5. Neither there was any specific pleading, nor any issue framed, nor any evidence led with respect to such relief. None of the purchasers, namely defendants 2, 4, and 5, entered the witness box. The High Court has carved out a completely new case, which is unsustainable in law. Thank you, students. Over.